Сейчас у нас начинается заключительная сессия, которая будет разделена на две части. Сначала мы выслушаем двух основных докладчиков, и после этого у нас останется время на короткие проблемные выступления. У некоторых коллег они уже заранее подготовлены по результатам исследований, по перспективам исследований, по практическим проблемам, по призывам к сотрудничеству. Мы их выслушаем, и дальше в режиме свободного микрофона все смогут сказать свои комментарии или поставить новые вопросы, дать обратную связь на все, что было сегодня обсуждено. Сейчас мы начнем с выступления Роджера Смита, профессора из университета Саутбэнк в Лондоне, о доступе к правосудию в связи с правами человека и развитием технологий. Прошу вас, Роджер.
Thank you. My presentation is in 4 parts. The first, I thought that it would be worth making some reflections on the system from which I come, the UK system, and how it seems to compare, contrast, be different, be the same, raise the same issues as yours. Secondly, I want to look at access to justice. That's my theme. In terms of human rights obligations. It's a relatively new child in the human rights block. Thirdly, I want to take a little deviation to look at business efficiency and technology, because I think that might be the area of the maximum impact at the moment of technology on legal practices of the kind that many of you have. And then thirdly, I want to follow a case through the stages of access to justice and look at a few of the products which have been developed in the UK and elsewhere as demonstrations of what technology can do. So in terms of my first part, observations, the UK is a relative newcomer to having human rights within its domestic law. The Human Rights Convention was incorporated in 1998 with effect from 2000. It took a bit of time for that to have an effect. The first cases that came through were about terrorism and crime, and now it's exploded. And something which back in 2000 the Law Society felt needed them to give every single practicing solicitor a green card summarizing what the legislation said, is now pretty well incorporated into our law, well beyond crime, and probably it has had its most effect outside of the areas of crime in relation to family law and so on. Our legal market is very different from yours. Our legal provision is very different. I think you can see us as having a number of layers. At the bottom, we have an advice sector which is funded by government grant, which uses volunteers and provides basic information, both digital, as we'll see in a minute, and face-to-face. The biggest known organization in that field is called Citizens Advice. Above that, we have organizations, again, largely in the not-for-profit sector, which combine that advice role with taking some cases. And there are about 40 law centers that do that around the country. A step up from that, we have practices which focus on low-income clients. They were, until formally, funded by government legal aid, and they're historically known as legal aid practices, although they've had to diversify more recently. And they provide the bulk of casework services in civil and in crime for poor people. And if not above that, around the same sort of level, we have a major pro bono contribution from the big city firms that in particular that dominate London's commercial market and have an impact on the provision of services for poor people. That's one element of our current situation. Another is that our government and our courts are going hell for leather. They are going fast to digitalize their procedures to save money. There is a major court digitalization program, which would be nice to talk about at some stage, but I'm not going to talk about it very much at the moment. It is being funded by selling off court buildings. And so there is a deliberate, and the court buildings are being sold before the digital processes are implemented, which is at best illogical. So this is going through fast, and mention has been made already of the digital divide. What do we do about people who cannot, for one reason or another, handle the internet? That is a bit of an open question in relation to the court digitalization program. And another part of digitalization is within ministries. We now have litigation about the grant. There's an automatic system, an automated system for the grant of visas. It probably is prejudiced, frankly, against citizens of the Russian Federation. It is certainly prejudiced against citizens of Nigeria and Libya. And that's the subject of litigation, as these things have been rushed in to save money and are cropping up with inconvenient legal problems. And another element of our world is that we're English-speaking, so we are very susceptible to influence from other countries, particularly the States. And I have a little tag that law is national, but technology is international, and the lessons are transnational. So a lot of the technology that's being implemented in the UK, in the legal services market, both the commercial and otherwise, is influenced by what is happening in other English-speaking countries. Sometimes it's the same product, sometimes it's a similar product. And finally, you cannot stray into this field, as we have, without talking about artificial intelligence. And it's clearly going to be really important and transformative. It clearly is very important and transformative in the field of commercial law, where it is really changing how people deal with thousands, millions of documents. In the field of access to justice, its effect is as yet marginal. And it is much hyped, it is much spoken up, but the actual impact of AI is really yet to be seen, particularly in access to justice, and I think outside certain specialist commercial areas. So we'll come back to that in a minute. So my second topic was access to justice and human rights. Now, in the UK, we are familiar with the concept of access to justice because every politician will proclaim that they support access to justice. It's become like motherhood and apple pie, something you cannot say you disagree with. But the definition is fuzzy. That's why it's so useful. And that's why it was developed by a bunch of academics at the University of Florence in the 1970s for a world study of access to justice. It's highly ambiguous about what it means, and the crucial dividing line about access to justice is, are you arguing for substantive justice, real fairness, or are you settling for procedural justice, something which is fair according to the law and the procedures which exist at the moment? And we don't need to resolve that, but it's an ambiguity hanging in the back of access to justice. Now, it's a late delinquent child to the human rights family, making its first appearance in Article 47 of the EU's Charter of Fundamental Rights and Freedoms, which says everyone shall have the possibility of being advised, defended and represented. Legal aid should be made available to those who lack sufficient resources insofar as such aid is necessary to ensure effective access to justice. Well, the meaning of that is to be discovered and explored. It makes a second return in the UN statement of its current set of sustainable goals, where number 16 is to promote justice and strong institutions, and one target of which is 16.3, to promote the rule of law and ensure equal access to justice. So this is a concept which is being taken up by the EU, by the UN, was a little late for the Council of Europe, but is going to make its way as an accepted human right. And we will come back to what that might mean in a minute. But I'm going to digress to a blank screen. I'm going to digress to business management, because before we get to how technology might help through different processes of a case, we have to be organized to take the case. And one of the great developments of recent times is the development of things like Microsoft Office on the one hand, and case management software of increasing sophistication in another. And I've put up just one example. I am not employed by Clio. I have no financial relationship with Clio. Clio is a Canadian company. I'm a Brit. But it's an example of a company which is developing sophisticated software for small and legal practices. It has just received $250 million worth of venture capital backing, which which my computer translates as 15 billion rubles. And so this is being backed by serious money. And if you reckon that for every dollar a venture capitalist puts up, it's reckoning on getting 10 back. This is being backed by serious money, and what it provides is, so far as I can see, a very adequate way of controlling your case. You can use it to chart your first contact with your client. It'll take you through the case. It will remind you of dates that come up. It will prompt you about documents. It will give you a case report. If you're the boss, it will give you a dashboard of how profitable that case has been and how profitable your firm is and how profitable everybody in the firm is. What is more, it's not only a product in itself. This is the genius of it. It's a platform. It's a platform which currently takes 297 other plug-in products. So they are developing this as a product in itself, but they're trying to make themselves the Google of the legal world. And so it stands as a good example of business efficiency. And it really can deliver that. One of the modules you can get for it is a pre-interview questionnaire of a client. And I have a friend who developed such a module himself, and he reckoned it saved 1/3 of the time in the original client interview if you took them through this pre-interview questionnaire. So it can save you money. It can make you more efficient. And it probably at this moment is much more important than the things I'm going to come to in relation to access to justice. This is a way of you being able to do, or lawyers being able to do more for less. I need the translation of this. These are the elements, I think, of access to justice that I would pick up. And this is sort of personal. This is not sort of accepted dogma, but I think it works as a division of access to justice. There is, first of all, the identification of the case and the law. So, do I have a legal case? It's the first question somebody asks. The second issue is the strategy. How am I going to adopt? What am I going to do? Am I going to lump it? Am I going to settle? What's my what's my aim as the client or the lawyer in this case? Thirdly, the evidence. How do I build the evidence for this case? And we're particularly concerned with what technology might do to help that. And then the fourth element would be referral and triage. If am I going to take this case myself? Am I going to refer it on? That won't be so important to you if you're a practitioner on your own, but it will be if you're a central organization of some kind. The fifth should be self-help. Can we use technology to help people help themselves in any way? And the sixth is resolution, and that would include online dispute resolution, the digitalization of the courts as the formal part of that, and the various informal mechanisms that there are for online determination. So first of all, the identification of the case. The first port of call for anybody in the UK, really, about law would be to go to a site not run by lawyers, but run by the Citizens Advice organization. It has a digital website, and you says search for advice up there in English, and you say housing, and it then gives you a series of options, and you then work your way through to getting advice on your case. It invites you to find the local office, which is the orange bit in the corner, and I think really nicely at the top right-hand corner, if you can't read English, it is telling you what cases have come up today. How many, in this case, whenever I took this screenshot, it was 72,000 people had asked about claiming compensation in the first bit, and then you get the numbers of the top cases. So it's a way also of indicating what is troubling people. And it's the first port of call. And the first thing to say about it is it's flat. Gutenberg would recognize this website. It's flat. It's like a book. It's like thumbing pages of a book. And really the point where we're at now, it seems to me, in relation to access to justice is how do we move beyond Gutenberg's book to an interactive use of the capacities of the internet? That's the whole story, it seems to me. How do we do it intellectually? How do we get the money to do it? How do we do it properly? How are we able to move from the safety of a linear procession of facts and figures and information to something which is interactive and rather more risky, where people may get lost or wrongly diverted? That's the issue, it seems to me, at the moment. Now, the whole story of where access to justice and technology lies in that movement, it seems to me, the move to interactivity. Now, one development from this is guided pathways. So instead of giving people access to the whole book, you take them through question at a time. So you take them through a question which has sort of 3 or 4 potential answers, and it guides them through so that you can control where they're going, and you don't present them with a whole lot of information all on the page. And the big example of that the best example of that is a website in British Columbia called My Law BC. All this is in the paper. And for family cases, that's what it does. It asks you, are you married? What do you want? Da, 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 da. And so it takes you through a guided pathway. That is a hairbreadth. We've talked about chatbots, and let's have a little chat about chatbots. We need to talk about chatbots. Number one, somebody asked about chatbots and crime. As far as I know, there are no chatbots in crime. Chatbots are civil, and they are a communication tool. And there are a number of elements to them. If you want to build a chatbot, one is, what degree of personality do you want to give the chatbot? Some greatly hyped chatbots are just a little chat box. Most of them are just a little chat box. You say, it comes up, it says, who are you? You say, Roger. What's your problem, Roger? And it's just a little box. And it's really just a guided pathway, taking you through from beginning to end. You can get them more sophisticated. There's a project in Chicago which deals with housing, and it has a little sort of cartoon robot called Rent-A-vention. So you ask Rent-A-vention problems about your housing, and it answers you, but it's all pretty simple. At the top end, it can get interesting. There was a Australian, a New South Wales disability benefit, where the government wanted to save money on the call centre. And it went to a New Zealand company, which has the wonderful name Soul Machines Limited. And Soul Machines make commercial chatbots. And they look like real people. And what's scary is they can see you through your screen, from your computer, if you haven't covered up and can respond to you emotionally, as well as, can say, you look unhappy with that answer, Roger. And they created Nadia. Nadia looks like a woman. She speaks with the voice of the Australian actress Kate Blanchett. She's a complete knockout. She is so sympathetic to your problem, and she was going to be the future. I personally was seduced by Nadia, and I wrote articles saying I have seen the future, and it's Australian, and its name is Nadia. Well, it wasn't, because the Australian government stopped funding Nadia. Because it made mistakes on other technology projects and lost a lot of money, so it was very nervous. And because the AI, which powered Nadia, which was the industry standard IBM Watson program, was not powerful enough to answer quickly enough. It took 50 seconds for Nadia to reply. Well, 50 seconds, you're lost. It was just too long. It was too long, it was too expensive, and it was a great failure. Now, that is not to say that sort of thing, that sort of development of a chatbot, was a development from a guided pathway to AI, with machine learning and all the rest of it. A faster program can't be the future again, and it may well be, because that's the way, if you ring up a commercial organization, that's what you're going to get. You're going to get Nadia Mark II or Mark 54. But chatbots, as they are at the moment, are basically crude. Very few of them really use AI, and they are pretty basic, but they can be ways of introducing people to new concepts. And crucially, as the point that Christina made to me yesterday, they can be verbal. You can speak to a chatbot. There are ethical discussions about chatbots in which it's being said that the chatbot must disclose they're a chatbot. And we're a long way from that. You get a chatbot, even if you got Nadia, you'd know this was not a real person. But there's a role there, but it's to come rather than currently is. So that's identification and dealing with problems. There's another element of AI which may be relevant here, which is the specific element of natural language processing. That's where a machine can take your something in a natural language, conventional English, Russian, and translate it into legalese, put it through a process, have the answer answered in legalese, translate it back. And that very limited use of AI is being explored. There's a project in the UK, there's projects in Australia, there's a big project in the United States about that. And that is something which is progressing and which it would be worth keeping an eye on, because I think that does have potential. The strategy I'll leave for one moment. There was a Dutch project called the Rechtwijzer. This is not illustrated by the slide. Do not be confused. The Rechtwijzer was basically a project, a way of dealing with divorce and online. And it asked you, what's your normal way of, how do you like to resolve problems? How confrontational are you? How confrontational is your partner? Well, in that kind of circumstance, if you can afford the money, have a lawyer. Otherwise, go for mediation. So the technology can assist in terms of the strategy. There are a number of products now which are about building the evidence for a case. This is an example from New York. It got a prize from a Dutch institution a year or so ago. And it's a way of, it offers you an opportunity to log into the machine if you've got a leaking roof, when it leaks. Something that's episodic, which it would be helpful to record. This is a way of recording it. There are a number of other products like this in relation to sexual harassment. There's one called JDO, there's another one called Project Callisto, and they are about allowing, it's generally women, to record incidents of sexual harassment, to keep them secret from everybody until there's another episode, either to them or to somebody else, and then making a match and then building a case. So technology can use its data retention capacity to help build cases. There are, on the outer fringes, some really interesting use of AI in relation to evidence building. There is an English institution attached to a university called Forensic Architects, which, for example, trained AI to look for particular types of canister of tear gas. And why did it want to do that? Because it was alleged that the US border forces were using this tear gas when they weren't authorized to do so to deal with Mexican immigrants. And they fed into the machine all the photographs they could find of disturbances between law enforcement authorities and immigrants to identify those pictures in which these canisters showed up. And as a result, the head of the company had to resign. Their involvement was exposed. It was a very successful use of the AI capacity for evidence. There are a number of institutions around the world that use AI for referral, which is sort of fairly, you can feed into, if you have a variety of organizations which will receive referrals, you can feed their data, who they are, when they're open, what their requirements are, into a program, and the system will then refer you on. It's a big issue in the States. This is an Australian copy which does that. I need help, I need to refer someone, my non-profit needs help. That's a different issue. There are a number of self-help products. This is the best known in the United States. And in essence, it's a terribly simple idea. This is called A to J Author. And as you can see, it is a terribly simple picture of a road to the courthouse with, in this case, 3 stops. Usually there are 6. And it says, welcome to Access to Justice, Author. And each stop asks you a question. What's your name? What's your address? What do you want? What are the relevant details you have? And then by the time you get to the courthouse, say it's a deed for change of name, that's what you want, the machine will have got all the information you need and will then print it out for you. And it's really widely used in the US. There are a number of English examples of this sort of thing. And it's beginning to be used, but people are exploring what you can do about that, and you can put twists to it so that, this is very simple, but you can take someone through the process of an appeal and you can give them more and more information about how they would be successful as they go through. So there are one of these systems for a disability benefit, and you can tell people, you can prompt people. You have pain in your leg, you can't walk. Is that constant? Does it come on at night? Give details of it. Make your case, build your case up in the way that a lawyer would, or if you were taking a statement from someone. Give me the full details. A lot of potential in relation to that. And then you have a number of explorations of online dispute resolution, the greatest of which is our Ministry of Justice's digitalization program. There are various other informal ways of having online settlement of a case. The problem with them is, at the moment, you don't get the court enforcement. So they will get you to a settlement through a variety of sophisticated or less sophisticated means, but they won't be able to enforce it. They have to, and it may have some weight with the court if you subsequently go there, but it won't actually solve things. So that's my... I have no idea what that says, but it probably says... I analyzed, I'm not going to go into this, I'm going to cut this. I analyzed 3 awards given by LexisNexis, which is membership of Tech Acceleration Facility, an organization operating on behalf, effectively, of the government, giving awards in the UK, and a third body. Anyway, and you can read what the themes were in the grants they made. I can't. But they were very much following up on what I've said. And this is just my final slide. Why do I know all this? Well, because late in life, I have got the dream job. This you would love. I am paid by the day, at my discretion, to write a blog about technology and access to justice for a foundation that I have tried to get guidance from, and all they've done when I've asked, I said I was going to criticize the court digital program, and they said, all right, we'll just put another disclaimer on the website. So they give me complete freedom, and if you want to read what's happening around the world, I don't think you could do better than go to law-tech-a-to-j.org, even though I'm a biased source. Thank you.
Thank you so much, Roger. And any questions coming? Вопросы? Коллеги? Вопросы к Роджеру? Для нас просто тоже, конечно, тема доступа к правосудию, она очень двусмысленная. Она, с одной стороны, с профессиональным сообществом, часто академическим сообществом воспринимается, конечно, само собой разумеющееся, а для публики исторически. Ну, я это знаю, потому что мы много работаем с правовым просвещением не юристов, публики. И для многих это очень примитивное право. То есть оно воспринимается как физический доступ к месту, где совершается правосудие. То есть он говорит, ну как же у нас нет доступа к правосудию? Идите на почту и отправите свой иск. Все. Доступ обеспечен. Чуть-чуть больше стали обсуждать физический доступ, особенно после того, как Россия почему-то ратифицировала Конвенцию о правах инвалидов. И стали больше говорить о физической доступности. Ну, вот, собственно, детальной проработки этого принципа, детального разбиения на очень конкретные элементы, на возможности и на гарантии их использования пока еще не происходит, либо это только начинается. Не знаю, какие-то возникли вопросы в связи как раз с технологией. Вот, тут, казалось бы, вот здесь простор для использования технологий, для роста бизнеса. В этом плане, пожалуйста.
Спасибо. Университет МВД, профессор Шахматов Александр Владимирович. Я бы хотел у Роджера спросить, можно ли при помощи чат-ботов использовать их в уголовном судопроизводстве, в частности, раскрывать преступления? Как вы считаете?
You can't solve a case. You can be advised about a case on a chatbot, but so far as I know, no one has tried to do it. And Clementina talked about the difficulty of predictive analysis for courts, and at the moment, the use of that technology is really for other professionals, for lawyers, and it has, as she says, a long way to go. So, no. And if you could, I wouldn't trust a chatbot, because if you have most criminal cases, it depends upon the evidence. And how can you get a chatbot to look into your eyes and say, do you look credible or not? So I think the major use, as I said, is civil and not criminal.
Вы не могли бы пояснить, что вы имели в виду? У меня есть подозрение, что это какая-то очень техническая идея, типа ловушки для преступников, которые честно признаются чат-боту в том, что они совершили, чтобы получить добрый совет, не зная, кто потом читает информацию.
Вы знаете, если ведущий позволит мне 1 минуту, я приведу пример, правда, он не наш, китайский. В общем, в 2 словах, буквально. Значит, 2 молодых человека жили вместе, дружили. Мужчина, китаец, узнал, что у женщины есть деньги, лежат в банке в этом плане. Сумма там небольшая, написано около 5000 евро. Значит, он решил ими воспользоваться. Видимо, они не пришли к согласию, и при разговоре он ее, в общем, физически убил, будем говорить, да, нанес ей смертельные раны. Но решил все-таки эти денежки получить. Каким путем? Значит, он через службу интеллекта в этом плане послал туда фотографию, было условие, чтобы деньги выдали. Значит, я так подозреваю, что что-то как чат-бот в этом плане решал, посмотрев на фотографию, разум сказала, пусть она мне подмигнет. Фотография этого сделать не могла. Тогда информация была передана полицейским соответствующие, они проверили, рассмотрели эту фотографию, увидели странгуляционную борозду и другие там телесные повреждения и раскрыли преступление, выехав. Спасибо.
Okay, well now you're asking, can you use technology? You're asking, can you use technology and artificial intelligence to commit crimes? Yes. It is a wide and fruitful field, and I wish you well.
Если я правильно поняла, то часть проектов, связанных с созданием каких-то технологических решений для доступа к правосудию, финансируется государством, участие негосударственное финансирование. Но я думаю, что и в том случае значимо, насколько эти проекты успешны, и есть ли данные, условно говоря, о долях отходов, да, то есть вот какой процент этих инициатив проваливается, а какой оказывается устойчив. Ну и, условно говоря, там, если планируешь проект, то насколько ты должен быть готов к провалу?
I think that's a really good question. And it's really difficult to find out what's really going on because people present their project the best way they can. And classically, if people are funded by a grant, the grant is for 2 years, a year or whatever, and you're rushing at the end, there's no proper evaluation done. So A, you have the problem of hype, people don't tell you the truth, and B, there's not really enough evaluation goes on, and C, most projects, and this actually is true of tech projects as a whole, but most of the access to justice projects that I know flourish during the period of the grant and then fold. You never see them again. So all the Legal Services Commission in the States has been giving grants at the rate of $4 million a year, 250 million rubles a year since 2002. Most of them have gone nowhere. They've risen and fallen. And it's extremely difficult it's extremely difficult to follow, and B, it's extremely difficult to work out, if you wanted to do it honestly and say, well, what are the criteria by which you would judge the project, that's quite a hard thing to do. And that's one of the challenges that we put to the Ministry of Justice, for example, in relation to its digital program. Well, if you were monitoring for access to justice, what would you be monitoring? What would you do? It's a problem I have in relation to my website. I mean, how many viewers should I reckon is reasonable in a month? I'm currently getting 1,200 users. Now, is that good or bad? I don't know, but I can chart it, and I think it's important, if you are involved in tech projects, both to chart them and to be open and transparent about that, particularly because the lessons are really transnational. So you could do something in Russia which would be really relevant elsewhere, and vice versa.
Мне кажется, юрист при исследовании вопроса должен проявлять настойчивость, поэтому вот все-таки насчет чат-бота в уголовном праве. То есть мы посмотрели презентацию, там есть программные продукты для формирования доказательной базы, там есть программные продукты для разъяснения юридических вопросов. Более того, мы знаем, что помимо принципиального правового решения, да, по уголовному делу, помимо приговора, есть вторичные процессуальные решения, которые выносит суд о применении меры пресечения, об аресте имущества и так далее. И еще и в этом смысле еще надо учитывать российские реалии, несмотря на все правовые гарантии, которые, да, прописаны в процессуальном законодательстве, в уголовном законодательстве. Целый ряд обвиняемых и подсудимых, не имеющих возможности оплатить адвоката, их правовые гарантии крайне слабы. Адвокаты по 51 статье, так называемые, по назначению государственные адвокаты, я думаю, что они по степени эффективности, ну, по крайней мере, часть из них, находится примерно на уровне вот этого идеального чат-бота. Вот. Поэтому все же почему, на ваш взгляд, невозможно? Это этическая проблема. Почему невозможен чат-бот, то есть программный продукт в сфере уголовного права и процесса? Спасибо.
You can have a chatbot. There's no problem in principle. A chatbot is a means of communication. So if you wanted to set a chatbot which would answer the question, I have been arrested, or I think I'm going to be arrested, what rights do I have? That's fine. It's just a means of communication. So there is no problem in principle. It would be just as it was in civil. I suppose the problem in crime is you rarely ask the question, I'm going to be arrested. You've been arrested, so it's all happened. So what can you do? And you probably need a lawyer. And if you're talking about a system of power imbalance, where you're talking about the citizen and a policeman, then one of the functions of the lawyer is his or her personal presence to balance things up. So a chatbot wouldn't do that. But if your question is about why can't we use chatbots to give information about the criminal justice system, which is tailored to specific questions people ask, the answer is there is no reason that you could do it. Try. I think it'd be interesting.
Yeah. Ну, понятно, то, что в России просто напрашивается чат-бот практически одним вопросом. Согласен на упрощенный порядок? Да, нет, что будет? В общем, выполнит функцию многих защитников по назначению. Пожалуйста, вопрос.
Спасибо большое за выступление. Совсем недавно на криминологическом международном клубе был представлен проект тоже программы или искусственного интеллекта, который назывался, если мне не изменяет память, «Электронные весы правосудия», именно для реалий российского права. И самый частый вопрос от криминологов, ученых был таковым: не будет ли снижаться квалификация судей при использовании таких программ? То есть они будут просто надеяться на точность и идеальность таких программ и не совершенствовать свои какие-то навыки юридические. Что вы скажете по этому поводу в сфере других разработок по правосудию с помощью искусственного интеллекта? Есть ли такая проблема? Именно квалификации.
I think that's an interesting question. I think if we're talking about advising people, the skills would go up, because what a chatbot or any automated system offers you is a way of dealing with the routine, the chatbots and technology in general, AI, is best able to deal with the standard question. It's the outliers or the difficult questions which raise issues where the machine doesn't have the data. So I think that judges could argue it either way. I'm not going to argue for judges, but for lawyers, I don't think lawyers have anything to fear from the expertise point of view, because they will always be needed because cases will be too complicated. And I don't believe that the AI has got now is anywhere near being able to deal with anything really sophisticated. And say the Compass program that, I can't remember now who referred to the Compass program, which was about, it was probably Boris, it was about bail decisions and custody decisions. That's pretty crude. So I think it's pretty crude. It's high volume, simple sort of decisions. It's the sort of thing that, as a lawyer, you'd answer in a sentence. It's the more difficult things that are going to come to the real living, breathing, and I think their qualifications will go up. And I will argue by analogy that will happen to the judiciary.
Thank you. Еще был вопрос? Больше нет вопросов. Давайте поблагодарим Роджера.